I'm also reminded a study from the U.S. Department of Justice looking at releases, 265,000 inmates released through 15 states, and looking at and comparing rates of recidivism to people who got 5-year sentences and more, 4 to 5, 3 to 4, and then 2 to 3, and then less than that. And what that research shows is the lowest rate of recidivism is among people who are sentenced to 5 years or more. The second lowest rate of recidivism is 4 to 5 years, and the next lowest is 3 to 4. And then below that, the 2, there's nothing going on. And I would say, of course there isn't, because you don't have people there for a long enough period of time. So,
just to conclude on that, the philosophical arguments about the negative effects of mandatory minimums that flow from mandatory minimums of the 10, 15, 20, 25-year variety, I understand you to be telling us are totally different than they would be from a 1 or 2 year minimum, mandatory minimum.
Right. Well, I would say that mandatories ideally would be long enough which would allow a judge to respect the goals of sentencing. We could look at it and say, yes, that's reasonable to assume that somebody would have the opportunity for rehabilitation. That would provide for public safety. There's a general deterrent effect. I think one of the big differences between Canada and the United States, as we all know, you can give somebody in Canada a 6-year sentence, and by law, they're eligible for release after 1/6. They can. It's not. We don't want to do as they have in the United States, where you're going to jail on the mandatory and you're staying there for your sentence. In Canada, fortunately, people have an opportunity to get out early.
Thank you. That's it.
Thank you, Senator Angus. We have Senator Joyal and then Senator Campbell, and then we will have to move on, I'm afraid. Senator Joyal.
Well, thank you, Madam Chair. Mr. Plecas, I would like to come back to the examples that you keep repeating of reoffenders who get 8 days and reoffend and get exactly the same amount of same length of time of sentence. We have got the benefit of the Canadian Centre for Justice Statistics testifying in front of us some weeks ago, and they provide us with 4 sets of results, and I have the chart here. I'm reading them in the record. For 1 month or less, 21% of trafficking. For a month to 12 months to a year, it's 56%, and from 12 to 14 months, 24 months, 6%, and 24 months and more, 16%. So in other words, 80% of people who are found guilty have a sentence more than a month to 2 years and more. And you keep repeating that case that you might have heard, but you seems to make a common rule of that case, which those statistics does not confirm. So could you give us the statistics that you have that pertains to situation whereby you feel that this situation you have described, is pervasive in the system? Because according to the stats we got, that doesn't fly with the results that we got from the...
Well, I haven't seen the stats, but just looking at that one page, I'm not thinking that shows you a trend there. But what I said was, I hope I said this clearly, is that our research, which looked at, for example, what amounts to 40,000 grow operations, if you look at BC and Alberta, and what happened with those cases. What were the characteristics of those cases? Who was involved in those cases? How did the system respond to those cases? And what I'm saying there is that on average, in the last year of the study, less than 10% of people received a jail sentence for production, and on average received a 4.5-month sentence. That's what those figures are showing. I can provide you with those reports. Now, when I referred to the other about the 8 days and the less than a month, that is I'm referring to a Stats Canada publication referring to, as I think I said, what happens on average across the board for sentencing in Canada. I wasn't referring to specifically to drug cases.
Well, that's important to make the distinction, because one would be led to conclude that in drug cases, you know, the court are more lenient. Well, according to those stats, it seems to me that there is a nuance to the contention that you explained to us and keep repeating as being, you know, an oral case. You know what I mean? A case whereby media keep repeating it, and then the perception is created that this is the situation in all the courts.
Well, it is the case in courts across the board for crimes. According to Stats Canada, it is.
But I think in fairness, Mr. Plecas, we are trying to focus on the crimes addressed in this bill.
Yes.
Yes, and I'm saying that the stats I provided you first are those which I have from our research, which says, okay, let's take every single case of a production case and trafficking case which was identified, came to the attention of police, and some of which followed through the courts to prosecution to sentencing, and what happened at the end of the day in those cases.
Yes, but
I think the simplest thing to do is going to be for you to send us the material upon which you're basing your testimony.
that would be very helpful, because you see, we have to understand one thing in the criminal penal system. If the Crown is not satisfied with the sentence, they can appeal it. So, you know, to conclude that the judge, you know, are the evil of our system is not, to me, and I'll put it in the most diplomatic term, not representative of the system. If the Crowns come to the conclusion that they are satisfied with a sentence, you know, they make a judgment on the sentence. The first one to make a decision on the sentence is not the accused, it's the Crown to decide if they are satisfied or not. They can appeal the sentence if they feel it's too lenient. So in my opinion, to focus on the court and the judges and the judges and the judges, to me, is politically loaded. And it's not a fair representation of how the system works. The system works in sync with the Crown, with the police, with the judge. And if the police is not satisfied, if the investigators is not satisfied, there's always a possibility for them to go back to the Crown and to see those guys are really bad, and they are the one that we would like to have a harsher sentence, and appeal the sentence.
Well, they don't, though, because they are guided by precedent and what's happened in previous cases. And the other thing would be is that in most cases we know that the sentence is a function of a plea bargain. So at the end of the day, I would also say I'm hoping that prosecutors are not leading the way. At the end of the day, it would be a judge. It is the judge, of course, who's ultimately responsible for sentencing. And all I'm saying is that in the research that I've done, the claim that and our expectation that judges would take into account, for example, prior record as an aggravating factor, and senior judges have said it is the most significant aggravating factor. I'm waiting to see that, because that just does not happen. It did not happen in our research, which I will send you, on drug crimes, and it certainly doesn't happen when we look at other kinds of crimes. It does not happen even if we're talking like offenses.
Okay. I'm very reluctant to say this, but I must. We have to move on. Senator Campbell.